Welcome to Off the Clock. This is a podcast by Procino-Wells and Woodland, where we take a team-centered, family-focused approach to serving the estate planning and elder law needs of our community in Delaware. I'm Amber Woodland, and I'm joined today by Michele Procino-Wells. We are super excited to come together today and talk to you about planning for young adults and the importance of having foundational basic estate plans as soon as a person turns 18. So welcome, Michele.
Thanks. Yeah, I'm excited to talk about this topic too, because it's one that a lot of people don't think about, and they should.
Yeah, I know it's near and dear to your heart too, because you have kids that are turning into adults.
Yeah, I do. So yeah, two of our boys are now in their mid-20s, and so we kind of lived through this in the college years, and then I've got my younger two who are now one has crossed over that 18 threshold and college and all of that, and then the baby, he's on his way. So yeah, so this is all something that I live on a daily basis.
Right. And as a planner, know how important it is that as soon as any of us turn 18, no one can by default make decisions for us. And so we just thought we would spend 15-20 minutes or so just educating the young people out there who, as soon as they turn 18, they really should be thinking about some of the things we're going to cover today. And I was recently talking to a client about the 5-year plan required for our irrevocable trust. And I said, so in 2030, your plan will be effective in the sense that it will protect assets from the cost of long-term care. And I stopped and I was like, oh my gosh, that's the year my daughter graduates from high school. And I came home that night. Yeah, I came home that night and I said to Layla, I said, I had a moment today at work that 5 years is all you have left before you're 18 and you're graduating from high school and going off to college. And it was just kind of one of those funny moments, like time just passes. And as parents, I think it's important for us to identify opportunities for our kids to have good, smart planning in place.
Right, absolutely. And it's something because, as you're raising your kids and, you're their legal guardian, and, a lot of people just don't think about when they turn 18 that you no longer have that authority to act for them. And especially if kids are, my kids all decide to go, they want to go far away to college, and the thought of, me not being able to step in if something happened, or me not having authority to get information, or me not to have or have to go through a hassle to have authority to make medical decisions for them. So it's why, I love how you said we're talking to the young people themselves, but also their parents. The parents need to be educated to know that, yeah, once your child turns 18, you no longer have any legal authority to act for them.
Mm-hmm. And I know it comes up for you because it does for me. Our clients who are in their 50s, 60s, 70s, 80s even have children or grandchildren that need to be thinking about this. So it's good education across the board for everybody.
And I'll tell you, I have actually created, documents for quite a few of our friends as their children, and when they're student athletes. It's even more important because there are actually some schools, I've been impressed, there are some schools that actually require their student athletes to have these documents on file at the school, because you figure they're traveling, they're participating in athletic events where they could perhaps be injured, and the school is trying to be proactive to know, okay, who has authority to make decisions for this student if something happens. But not all schools do that. Not all schools are thinking about it.
Yeah, so super important. I have taught juniors and seniors at Salisbury University about estate planning, and one of the very first things I asked them in one of the very first weeks of class, how many of you have ever thought about creating powers of attorney or healthcare directives? And they all just looked at me like, none of us.
Right.
Yeah.
Unless their mom's a lawyer. Yeah.
Yeah, exactly. Yep. Yeah. And like you said, there can be medical emergencies. There can be the need for just convenient financial access. And it's just important to have these documents in place. So let's break down the two primary documents that we want to focus on, which are the power of attorney and then the advanced healthcare directive. And if you just want to take a few minutes to first just explain the power of attorney first, and why it is probably the most important estate planning document that anyone can create, but how it directly relates to young people.
Yeah, so power of attorney, legal document in which You name an agent, which is just a person that would have legal authority to act for you with respect to typically like financial or legal types of matters, if you become unable to do those things yourself. Or, they can also be set up so that, if you're going to be out of the country for an extended period of time or out of commission because of surgery or something like that, where you've got somebody who can step in and have legal authority to help you manage your life. So, important to name at least one agent in that document. Typically people name, at least one successor. You can name co-agents. Oftentimes young people, when they're creating these documents, will name, both of their parents as co-agents, or perhaps one and then the other as alternate. So that's really important to think about. But the document needs to be really thorough. In Delaware, in particular, there's a whole set of specific authorities that need to be included in a power of attorney document. So you can't just have a document that says, oh, I give my agent, full authority to do whatever I could do for myself. That's not good enough. It has to have very specific language in the document in order to give certain authorities. So it's really important to make sure that you're using an appropriate professional to create that document.
I think it's important to talk just a minute too about the state of residency is the state where the document should be created. And then I think a question that could naturally come up, is it valid in Georgia? Is it valid in Florida if that's where the student is then going to college?
Yeah. So typically you're always going to create that document in the state in which you're considered a resident. So like my boys, two of them decided to go to Georgia to college. Yeah. So we didn't go out and create Georgia powers of attorney. So typically a power of attorney document, if you create it in the state of your residency, that's going to be upheld anywhere else. So yeah, I mean, it wouldn't be wrong to have one done in the other state, but typically, it's good enough to have it done in the state in which you're a permanent resident.
So going back to my students at my SU class, when I asked them if they had a power of attorney and none of them did, I said, well, certainly your parents are still making financial type decisions for you. How are they doing that? And they're like, well, kind of. I mean, they send us money. It's like a one-way thing.
Right.
And I laughed and I said, yeah, they could send you money, but then once it's in your account without the proper authority, if something should happen to you, they're not going to have rightful access. And so sometimes I think at 18, 19, 20, 21, those kids are learning their independence and they don't necessarily want their parents still meddling in their business. Do you want to just talk a minute about how powers of attorney can be effective, when they're effective, and just to give young people the peace of mind that it's an important planning tool, but it doesn't necessarily mean that it is going to be used.
Right, exactly. So thank goodness, knock on wood, I've never had to use my son's documents. Hope I never do. But yeah, it's a really good distinction because you have the option when you create the document to make it what's called a springing power of attorney, where it would only kick into effect if a doctor were involved and if a doctor declared you legally incapacitated and said that you no longer have the ability to make your own decisions, and therefore then your agent could act. Or most people create their power of attorney documents with immediate authority, just meaning that it wouldn't require a doctor, so your agent could act for you at any time. But legally, an agent can only act when it's appropriate. So like for my sons, naming me as their agent, it doesn't mean I can just do whatever I want at any time. It doesn't allow me to overrule them. It doesn't allow me to go and snoop around in their bank accounts and that kind of thing. It's only to be used when there's an appropriate situation. So sometimes people, when they read all the language in the power of attorney, it can be a little scary because you're thinking, oh my goodness, I'm giving all that authority to my named agent. But those authorities can only be used when there is a legitimate purpose that's in the person who created the document's best interest. Right. So that's an important distinction. But you do have that option of making it a springing power for someone who is uncomfortable with that authority being in place right away.
And I just imagine if there was an emergency situation and the parent needed to step in, how much easier it would be if this document was in place. Otherwise, crisis, panic, cost, delay, all these things can creep in without it.
Right. And we've seen those situations too. Like if you make it dependent on a doctor's opinion, getting a doctor's opinion can be really difficult depending on the situation.
Yeah.
But yeah, because, when a person doesn't have a power of attorney, it's, you said it, it's why it's the most important document. The only other option is to get a court appointed guardianship created and have the court, officially declare a person, legally incapacitated, and then that's court supervised. And that process usually takes months
Mhm.
from start to finish. So having a simple power of attorney document in place, is by far, best practice.
Yep. So then flip the coin over and talk about the medical side through the Advanced Healthcare Directive and how it's a separate standalone document and the components of the Healthcare Directive and why they're equally as important.
Right. So the healthcare directive, very similar to the power of attorney in that it allows you to name an agent who can make medical decisions for you if you're unable to do that yourself. And that's why, I said the power of attorney really is like legal and financial, because the healthcare and medical decision making is covered by the healthcare directive. The document that we use and what's authorized by the statutes in Delaware also allows a person to have living will provisions in place that address end of life care, in terms of the use of life prolonging procedures or not. And it also allows a person to put their wishes in place related to organ donation, which is really important, especially for a young person, because a young person, certainly, my goodness, if a young person passed away, they would perhaps be a candidate for transplantation purposes. So really important to know a young person's wishes in that regard. So that document is a really great document to have in place. So again, who can make those medical decisions for you, but then to have your wishes, related to those other things in place also.
Yeah, I always describe the healthcare directive as such a gift to the people that love us. I think that if we were ever in a medical crisis and we had our own wishes on paper, what a gift that is to the people who love us, because then hopefully they're not in the decision-making role. They're
Right.
just carrying out our instructions that we've already put down on paper, and they don't then live with the decisions that they made in terms of life-sustaining treatments or not, or organ donation wishes.
Yeah.
And I think it's great. Young adults also have opinions about transplantation and donation for educational purposes. And this is the best place to do that, because just telling the DMV that you're willing to be an organ donor isn't enough. And that's actually not legally binding. It's just more a statement of intent. So outlining your wishes specifically in this document is really, really smart.
Yeah. And the fact that you can designate for what purposes you're willing to donate, if you have it on your driver's license, it's just a little red heart, it doesn't give any detail on whether you would be okay for research or education or just transplantation or what. So it is nice. And it's such a simple document to create.
Yep. Yeah, we often call the power of attorney and the healthcare directive companion lifetime planning documents. You need both.
Right.
So that you have covered all your bases, financial, legal, and medical decision making during your lifetime should you become incapacitated. Do you want to take a minute or two and just talk about the one end of life document that young adults might want to consider, which would be a simple will, if they do have assets and might be interested in creating a simple will and what that would do for them?
Yeah, so wills are just part of a basic foundational estate plan, and sort of when you're at it, creating a power of attorney and a healthcare directive, it certainly doesn't hurt to create a will, even if a young person doesn't have much in the way of assets yet. Because a will also designates an executor. So, if something happened and if, say if I always hate using these examples, but if a young person were killed in a car accident or something, and perhaps there would be litigation, then an estate would need to be opened for that person. And who would you want to be named as the executor of that estate? So having a simple will, and then because what happens too, you create that simple will, and, now my older sons are at the point where they, have little investment accounts and they've bought cars. They're starting to accumulate a little bit in the way of assets. So they do need to have wills. And so it's nice, to have that. It's kind of just smart to create that, when you're 18 and when you're creating, those other documents. And then obviously, an 18-year-old is, more than likely going to name parents as their agent, maybe name parents or siblings or whomever as their beneficiaries. And then, when that significant other comes around or they eventually get married, they obviously want to, keep an eye on their estate planning and update it over time. But yeah, really smart to have a will also, even at a young age. And it doesn't depend on owning a bunch of assets, to be needed.
Mm-hmm. I'm thinking too about high school graduates who maybe don't go off to college, but who start their first jobs. And especially if they're starting high risk jobs. My brother is a police officer, and it was really, really important when he started his career that we had the power of attorney and the healthcare directive and a simple will in place.
Right.
So it really does apply to everyone as soon as they turn 18. And I think you also hit on such an important topic, which is plan maintenance. If we get young adults to see the value in doing simple planning while they're young, and then maintain it and update it as things in their lives change, they're just always going to be in a position where they have a really great estate plan, no matter what season of life they're in. And as they get married and as they accumulate assets and as they have children, the planning can always be adjusted and modified. But I think it's best to not fall into the trap of, oh, I'll wait and do my estate planning someday, or I'll wait until I have assets, because power of attorney and healthcare directive are needed whether there are assets or not. We often, I'm thinking about how often we see young parents creating estate plans and then not ever looking at it and redoing it until 30 years later when they retire and dusting it off. And that's really not best practice, because if you can do it young, get it in place, and then just over time, check it. Make sure it's still doing what you want it to do and update it as needed. That would be best.
Right. Absolutely.
How about document storage and digitally storing these types of documents, and whether photocopies are valid in place of the originals? You want to talk a little bit about, what you've told your boys to do in terms of document storage and easy access for you as their agent?
Yeah, I mean, the nice thing, a will, you always need the original of a person's will when they pass away, and that has to be filed at the Register of Wills office. But the other documents, powers of attorney and healthcare directives, copies of those documents are typically accepted. I don't know that I've ever heard of a situation, unless a power of attorney document needs to be recorded for like real estate transactions, that kind of thing. But otherwise, I've never heard of where the originals of those documents were required in a situation. So, always smart to have the originals, stored in a safe place. Sometimes, maybe a bank safe deposit box might not be the best idea for those in case there is an emergency situation and the bank's closed for the weekend. But certainly have copies of the documents. We now create digital copies of all of our clients' documents and provide those to them in our portal. And so I think it's smart to have those saved on your computer so you can quickly, email it to someone or print it, or, there are online storage services too where you can store those kinds of documents. So usually though, I've had clients say to me, well, gosh, should I keep my healthcare directive, in my purse at all times? And, usually you don't need it that urgently. A power of attorney document, you typically don't need that urgently. With healthcare, if you go to the emergency department, they're going to treat you, they're going to stabilize you. But maybe when a decision needs to be made about surgery or something like that, maybe they'll want your agent, they'll want to see that document. So you have to use just common sense in terms of storage. But yeah, having those digital copies, certainly is smart, so that way you can easily send it to someone when needed.
Yeah. Well, I think just to wrap up the conversation, you want to just talk out some misconceptions or maybe some planning opportunities or some myths that we hear, just to kind of summarize. I mean, we've already talked about some of this, but I think one of the biggest, just to kind of reiterate this, is the myth would be, I don't need an estate plan until I'm older, or I don't need an estate plan until I'm sick. And I think we've already addressed, like, as soon as a person turns 18, they really need to be thinking about these critical foundational documents. I used to joke in terms of asset accumulation when I was first starting out with a bunch of student debt with my clients, like, I don't have any assets either. I actually have more debt than I have assets, but I still have a good estate plan. So, don't let life moments dictate when you create the documents. Essentially, there's the best time is as soon as you turn 18, and then as circumstances change, keep it updated and modify it as needed throughout life.
Right.
Um,
Absolutely.
how about the, like, I don't even want to think about it because that's just bad luck. Did you hear that?
Yeah, I do. Yeah, I take just the opposite approach. I'm thinking, okay, if I do the planning, if I have everything in place, then nothing will happen. It's when you don't do the planning is when the horrible things occur, and then you're in a mess. So yeah, I mean, we've heard that from people saying, oh, I feel like if I were to create a will that I'm going to die. Yeah, no. Yeah, I think the scarier thing is, that not that I will die if I create it, but if I do die and I don't have it, that's a mess. Like, I
Yes,
think that is the much scarier risk.
I agree with you. Yeah.
Yeah.
I also know about both of us, and I'm sure a lot of people who are listening to this, we want to be in control. And the best way to be in control is to put what we want on paper,
Right.
because otherwise we don't have control. And that is what feels scary to me,
Yeah.
you know?
Yeah.
So yeah.
Yeah. Yeah.
We talked about kind of the myth that parents would meddle too much in their kids' business using this document. I thought you did a really good job of talking about, no, the agent named if it's the parent is a
Right.
fiduciary, and they've got to act in the best interest of the child.
Right.
But would you elaborate just a little bit more on picking the best person for the job in terms of nominating the agent and
Yeah.
the executor under a will, and what kind of skills we would be looking for in that fiduciary role, and whether that be a parent or a sibling or an aunt or an uncle?
Right. Yeah. Yeah. I mean, you always have to, and this is across the board, whether it's a young person creating these documents or someone, an older person, you always have to really try to, be as realistic as possible and think about who is best for the job. And, you want that to be someone who's going to be honest and diligent and a good bookkeeper and provide information to other parties who are involved. And, sometimes it can be a really hard decision. Sometimes, you got to pick maybe not the person who is the most obvious. Clients often, we see it, they want to name, or they feel like they should name the oldest child. And, maybe the oldest child isn't the best person for the job. In this context of for young people, I find that often, I said it earlier, that often they'll want to name both of their parents as co-agents. And you got to decide if that makes sense, because even if mom and dad love each other and live together and get along really well, having two people named can be cumbersome depending on their situation. If you have a child whose parents are perhaps divorced, that might not be a great idea to name them both, because that could be even more cumbersome, especially if there's any conflicts between them. So for all of these roles, you really do have to look at the people that you have to choose from and decide who is best. And sometimes that means going outside your immediate family to more distant family members or professionals. Some of our clients name our firm for these various roles, but it has to be like I say, kind of a hard conversation, and you have to also kind of take a step back and imagine what that's going to look like someday when you're not in the mix. Like if somebody else is acting for you, what are all the relationships going to look like? So
yeah, thank you. I think the final myth or misconception we should talk about is just the cost to do planning, and why a young person shouldn't see that as a preventative, because I know you've been through it, and I know firsthand how expensive education is. And I know that there will be some parents who listen to this and think, gosh, we are already just bleeding cash because of all the expenses of sending our kids off to school or into their next phase of life. And then to spend money to do estate planning, that could be prohibitive. And so you just want to share some of your just insight about prioritizing the cost, and also what it would cost to not have this done.
Right. And that's the whole thing. It's kind of the risk of, yeah, if something happens and you don't have these documents, I mean, you are looking, if you have to do a court appointed guardianship, I mean, you're looking at usually spending a minimum of $4,000 or $5,000, even when it's not contested, because it's a whole process that you have to go through, and there's court filing fees and such. So yeah, no, I definitely, yeah, when you're at that point, when your child is, just turned 18 and they're headed off to school or they're starting their job or whatever, yeah, there can be a lot of expense, but this really should be a priority because it is so important. And again, because the cost, if something happens, the cost of, then trying to go back and get authority that's needed is, 10 times the cost of having these documents put in place in the first place.
And so is there a situation where if a parent or a grandparent wanted to gift the young adult the money to cover the cost of these services, you want to talk just a little bit about who we owe the duty of confidentiality and loyalty
Absolutely.
to, but who actually can pay the bill? Because I think there might be an 18-year-old listening to this and really understands the importance of it, but simply just can't come up with the funds to cover the cost.
Yeah. And I'm thinking, I have a close friend of mine, her daughter was headed off to college a few years ago, and they asked me to prepare documents for them. And they absolutely, they said, no, we're going to pay for it, for her. But I made it very clear to them and clear to their daughter that the daughter was my client. And that I spoke with her separately from, mom and dad. I made sure that she understood the document. I made sure that she, knew who she wanted to name. I shared with her that if she didn't want them to be involved in the process at all, that they didn't have to be, that we could meet just the two of us. If she wanted to name someone other than them, she could. Didn't matter who was paying the bill. They could pay the bill all day, but they weren't going to be our client. The young person was the client. And, I tried to make that. And of course, she ended up naming her parents and she wanted them to come, so she was particularly, but I gave her the option, and I made sure that she understood. I made sure that she had plenty of opportunity to read the document herself and understand it and go over it with her. So yeah, it's a really great point. Of that the young person, whoever's signing that document, that's our client. Doesn't matter who's writing the check.
Right. Awesome. Well, do you have any final words of wrapping up this?
No, I think this powers of attorney and healthcare directives, they're documents that you create and you hope you never need. Right. You hope you maintain your capacity, but we see them every day in our practice where those documents are vital, and we see people, our clients' agents using those documents regularly, and it really is a blessing to a person's family when those situations come up and somebody else needs to act for them and that they've got the appropriate documents.
Awesome. Well, thanks for your time, Michele, and thanks for all of those listening. We appreciate it. Thank you for being with us on Off the Clock. If you'd like to learn more about us, visit our website at pwwlaw.com. You can always call us directly at 302-628-4140 or by emailing info@pwwlaw.com. We're here to help you plan today to protect your families tomorrow. Anything discussed on Off the Clock is for general informational purposes only and is not intended to create an attorney-client relationship. To obtain the most reliable guidance, listeners are encouraged to seek personalized advice from qualified professionals.